Right, we have put the session under recording now. I'm hoping that we'll be able to have more interaction from now on. It's a bit frustrating when I only have myself talking to the screen, and the only image I see is myself. So please do interrupt, do raise questions, and we can discuss those issues that you raise. I saw that some of you have acknowledged my question, have responded to my question that, some of you have received the materials, but Stephanie says no. Is that what you meant, Stephanie? You haven't received yours, have you? Or Stephanie, haven't received. Right. It's a pity. Can you hear me?
Yeah, I hear you.
Oh, that's good.
Yeah, maybe because I live really far, so like I haven't received yet. But I'll try to check my mailbox like these days. Maybe it'll be arrived soon. I hope.
Right.
Okay.
Of course, there is that textbook that referred to.
Yeah.
That, of course, you will have to get it yourself. I'm hearing a lot of echoing. I don't know whether it's my microphone, my system, or yours. But I'll try to turn off yours first. Yes, I think, unfortunately, yes, I was hearing some echoes when I turn on your mic. I turn on Stephanie's mic. Lower your speaker volume. Let me lower it then. Right. Thank you. Down a little bit. Okay, good. So we will. Let me see how many have we got here. Still got a few to come. Maybe I'll give you this time, this opportunity to anyone here, uh, if you might have any questions to ask on we had covered um, in the last two lessons last week. Is there any question that you would like to raise so far? We have looked at the historical aspect relevant to the basic law, and we went back as far as the time when the UK occupied or took Hong Kong, occupied Hong Kong, if you like, as a colony, following the Treaty of Nanking, which wasn't recognized by uh, mainland, by PRC, and then we went to where the um, concept of one country, two systems was reflected in the amendment or in the national policy towards reunifying Taiwan, and the amendment made in 1982 to the PRC Constitution, which allows the establishment of special administrative regions by law, and in which other system other than socialist system may be practiced. Then we look at how the joint declaration came about when UK and PRC started their negotiation on the future of Hong Kong. We then look at the joint declaration itself, which is an international treaty between the two states and is now deposited in UK. And we went through it. It's a short document itself, in which China declared its basic policy towards Hong Kong, set out in brief form in the joint declaration proper, and then in very detailed form in its annex. And then we took time to go through the joint declaration alongside the basic law, and we did a matching exercise and identified provisions in the JD, in the joint declarations, which appear in the basic law, some of which word for word or very, very close in the wording. And then we went to the, if you like, looking at the basic law from both the international and domestic context, and of course that's where we stopped last lesson. Now a very quick, that was a very quick account of what we had done so far. So questions, any of you? If you have no questions, then I ask you the questions then, can I? Right. Can anyone tell me where did we stop? On which slide did we stop last time? On which slide? Which was the slide that you looked at last time before we broke, before we ended the class? Yes. Good for you. Yeah. So we were looking at 47, and here we are actually in the context of looking at what we call the domestic dimension of the basic law. This is to bring in the context of the Hong Kong Basic Law, or rather the context of the Chinese PRC legal system, and then find the proper place for the Hong Kong Basic Law. That is important, not only to find out what the content is, but more so identifying and therefore have the relationship between the central authorities and the Hong Kong Special Administrative Region put on its proper plank, its proper relationship, the nature of it and the substance of it. Yeah? And in order to do that, of course, we have to know, and we have to know, not only know, but we have to understand what sort of constitutional structure that the People's Republic of China has. And in order to find out that, of course, the primary document is the Constitution of the People's Republic of China. And I could take us, we can sort of go back to the slides that we looked at, and then and from there we can refresh our mind on what we had looked at, and therefore can carry on with it tonight. And the body which enacted the Hong Kong Basic Law was the National People's Congress. And this is described as the supreme organ of power within the People's Republic of China, which is a unitary state. And all powers go to that, rests with that body. And this is very different, or in fact, is entirely different from states like UK, US, or Canada, Australia for that matter. There's no separation of power as such. This supreme organ of power exercises all the powers of lawmaking, governing as the executive body, and to a large extent performing the function of overseeing the courts in the country. It doesn't normally or it doesn't perform the role of adjudication. That's left to the courts, but it does perform the function of overseeing, supervising the performance of those functions by the judiciary. So that is a very, to many of us who are more exposed to the common law systems and parliamentary systems, will find this very unusual. Because the Hong Kong Basic Law is a national law enacted by the National People's Congress, that law itself, the Basic Law itself, contains rules both for China and as well as Hong Kong. Now, we have to read this very carefully, because China conceptually includes Hong Kong. So when it sets out rules for China as well as Hong Kong, this is in the context of the one country, two systems, right? So Hong Kong as a system different from that of PRC is bound by these rules, and so as PRC, so as China. So that we have to read this very carefully with the right in the right context. So this is the National People's Congress. some of you may have been to this great hall of the people, and this is the place where all the most important laws are made, and these important laws are called basic laws. All these are basic laws. Well, what are they? Such as the Civil Code, the Criminal Code. These are the basic law. These are the basic laws. The Constitution doesn't define. There's no definition as to what is a basic law. We can only deduce it from examples of the laws that were made by the National People's Congress. And that's why in order to avoid confusion, we very often we will refer to the Hong Kong Basic Law as the Hong Kong Basic Law rather than just the basic law. And according to Article 62 of the PRC Constitution, the National People's Congress exercises many functions, one of which is to enact and amend basic laws concerning criminal offences, civil affairs, the state organs, and other matters. NPC has many members, and there are over 3,000. But 3,000, although it probably is the largest body of this kind in the world, but in terms of percentage of representation, that may not be the case. China's population is huge. What is the population of China? Yeah, 1.4 billion. Yes, quite. So you can work out the percentage may not be that high though. For example, in UK, I think they got in UK Parliament there are around 650, let's say 640 something, and that's against a population of I think 50-60 million. So Hong Kong, of course, is a small place. We've got a population of 7.8 million, under 8, and we've got 70 elected members in Legislative Council. Each term is 5 years, and as far as the plenary body is concerned, the National People's Congress is concerned, it only meets once a year for 2 weeks, and usually in March. For this year, of course, they met in May instead because of the pandemic. Right. So it's just common sense that this body, because of the size of it, in any event, it's not very effective, and of course the time that it meets is also very short, in a year. So when it meets, it of course deals with the most important tasks that's meant to do, and during the rest of the time, its functions are carried out by its standing committee. The standing committee meets every 2 months. Which again is not law as such, but it doesn't meet every day or every month. But normally we will have said normally they would meet in the even so-called even numbered months, the February, April, and June. But like this year, they met in May again because of the pandemic, and sometimes they hold extraordinary meetings in order to deal with emergency matters. And like important matters that affect Hong Kong, yes, when the Standing Committee is making interpretation of the Basic Law, or even in the latest event was the enactment of the National Security Law that took place in June, remember, and it was June 30th, 11 p.m. That piece of national law was promulgated in Hong Kong and became and apply in Hong Kong, start applying in Hong Kong. So that's the Standing Committee. The concept I want to raise at this point is this, just echoing what I had said earlier, that the Basic Law, because the Hong Kong Basic Law is Basic Law, it is a piece of national law. So it sets out rules restricting what the Chinese authorities are allowed to do in Hong Kong. And what would be the most prominent example? There are quite a lot of those. Article 22(1) is the often quoted example, and that is set out on this slide. It says no department of the CPG, of the Central People's Government, and no province, no autonomous region or municipality directly under the CPG may interfere in the affairs which the Hong Kong Special Administrative Region administers on its own in accordance with this law. So that had been seen as a clear restriction imposed on these group of bodies referred to, not to interfere with the affairs of Hong Kong Administrative Region. And it sometimes had drawn a controversy because of the establishment of some offices, or departments in Hong Kong by the CPG, where the controversy being that seemed to be in contravention of this particular article. Such incident, I think the latest incident was the discussion on whether the establishment of the office on the national security in Hong Kong was actually in contravention with the Basic Law, and therefore it was in contravention with the Basic Law. I'm trying to turn up the name of the body that was established here. We have, of course, the Committee for Safeguarding National Security of the Hong Kong SAR, which which is being chaired by the chief executive. It's being chaired by the chief executive, right? And that itself is not a department of the Central People's Government. But as far as the function of the CPG is concerned, Article 3 of the National Security Law made it clear that it is the Central People's Government which has the overarching responsibility for national security affairs relating to Hong Kong SAR. And the duty of Hong Kong SAR is to safeguard national security, and any institution, organization, and individuals in Hong Kong shall abide by this national security law and also the laws of Hong Kong SAR. So that's the national security law, and I'll come back to this law later when we discuss about the how national law other than the basic law may apply to Hong Kong. I was looking at a very, suddenly escaped me. That's right. It is actually Article 48 of the National Security Law, which provides that the Central People's Government shall establish in the Hong Kong SAR an office for safeguarding national security of the CPG in Hong Kong SAR. And then it has to perform several functions. Some are preventive functions, some are investigatory, and indeed one function which drew a lot of discussion is the fourth function under Article 49, which is to handle cases concerning offences endangering national security in accordance with the law. Now this is where there was concern raised that this the establishment of this office was in contravention with Article 22(1). But the counter argument is that this is not within those departments contemplated under Article 22, and it performs a specific function in safeguarding national security. It also raised concern that this body of the Central People's Government has made inroad into the both investigatory power and power of adjudication of the Hong Kong SAR under the high degree of autonomy by giving it the authority to handle cases concerning offences endangering national security. The counter argument is saying that this only concerns exceptional circumstances where it involves international elements, and also that it has proven that the Hong Kong Special Administrative Region government is not capable of handling because it's too complex and it's difficult and is unable to effectively enforce the national security law, and there was a major and imminent threat to national security that has occurred. And this is provided under Article 55 of the National Security Law. So that you can see that, and I think it's fair to to say that as far as this, in order to address this particular situation, I think those responsible for drafting the law had found a way to balance the interest and interest of the SAR of being a high SAR enjoying high degree of autonomy and the national security of the state. We may go to that law again later on when we look at the protection of human rights. Yeah. Cool. Okay. So this is Article 22(1). So are there any questions on this? We are now actually looking at the domestic dimension of the Hong Kong Basic Law. Domestic being within China. Within China. Okay, good. You will see that in your manual, page 35, there's a reference to the case of Zheng Jikang, and that was a case that happened in the 1998. I wonder if you may remember this. Some of you may have read about this. Some of you may actually, well, I mean, 98 was, how long was that ago? That was just 21 years ago. I think many of you probably was aware of this. It was big news then. And Zheng Jikang was some criminal wanted who had committed a crime in Hong Kong. And the crime including kidnapping a Hong Kong person, Hong Konger, and allegedly the planning was done in on the mainland, but the actual kidnapping, the actual crime was committed in Hong Kong, and eventually, while being a wanted person, he and his gang actually, but Zheng Jikang was arrested on the mainland in Guangdong, and there was then a debate, a public debate as to which court should have jurisdiction over Zheng Jikang. And in that context, there was a debate over which law should prevail, which law should apply, the Hong Kong Basic Law or the National Code, the Chinese criminal law should apply. Under Chinese criminal law, Article 6 and 7, the mainland authorities have jurisdiction over any Chinese national, no matter where they are, as long as they are suspected of having committed a crime. The Hong Kong law, of course, is based on this jurisdiction. The power is based on where the crime is committed. If the crime is committed in Hong Kong, then it doesn't matter what nationality the person who committed the crime is within the court's power to deal with it. And even if the crime happens, part of the crime happens in a place outside Hong Kong, as long as it has close connection with Hong Kong, then Hong Kong courts can deal with those cases. And in this case, we have an apparent conflict and competition between the Hong Kong court and the mainland court. And the result of that case is such that the trial eventually was held on the mainland, and it did not happen in Hong Kong. Of course, if that was a case which had brought into focus about a lot of what we call cross-border crimes, so-called cross-border. In fact, again, to be more neutral, we will say commission of crime which involve both Hong Kong SAR and the mainland, because there should, in strict legal terms, there's no concept of border, no border between Hong Kong SAR and mainland, because they are of the same country, so there's no border as such. That is one case, and the more recent case is the case of Lei Bo, the bookshop keeper in Causeway Bay. That, if you remember, also had drawn a lot of debate, and that went to the extent of the discussion involved suspicion that some mainland law enforcement agencies were in Hong Kong physically who had arrested Li Po. That was denied by the mainland authorities, but again bringing into focus the respective powers of Hong Kong SAR authorities and those from the mainland. And so in the context of the basic law, as far as general crime is concerned, as far as I think they still kept quite distinct and kept quite clear. And unless there's law or arrangements sanctioned by law, there's no legal mechanism for transferring anybody suspected of a crime in Hong Kong, or for that matter on the mainland, to be transferred to the other place. All right. This is a problem or a situation that has to be addressed because of the one country, two systems. Because it's one country, two systems, and therefore the normal rules of extradition do not come into place, because Hong Kong, being part of China, will not have the capacity, and nor is it right to enter into any sort of agreement like international treaties. It has to be an agreement entered and sanctioned under the basic law. And the basic law, in fact, if you turn to Article 97, this is and the basic law does envisage a collaboration between the mainland authorities and the Hong Kong authorities on the juridical matters, on matters that involve the courts and law enforcement. And let me just take you to that with the article. This is Article 95. Article 95. The Hong Kong Special Administrative Region may, through consultation and in accordance with law, maintain juridical relations with the judicial organs of other parts of the country, and they may render assistance to each other. Right. So this rendering of assistance is there. 95 concerned about mainland and Hong Kong SAR. Article 96 then authorizes Hong Kong Administrative Region to deal with the governments outside of China to enter into appropriate arrangements for reciprocal juridical assistance. Right. So this matter of rendition have been in the have been under discussion between mainland authorities and SAR, Hong Kong SAR authorities ever since 1997, but they have not yet entered into any agreements. And of course, we remember last year, 2019, it was Hong Kong SAR government in, I think, end of February, early March, introduced a bill which apparently seek to address this issue. And with the backdrop that the law, the general ordinances which govern this sort of relationship had excluded, and still they do exclude mainland China and Macau from their application. And of course, we now know, and from looking back the 12 months since 2019, or longer than that now. Now we are now end of 2020. It had attracted a lot of criticism and also protests, and eventually led to Hong Kong undergoing some difficult times since June last year. Right. So I think we all remember that. Oh, are we there? Yeah, we all remember that. And I'm going to talk more about that later in another context, about more about the law that's being maintained under the basic law, the pre-97 law. Right? We'll look at that later. Okay. So I wanted to move on to looking at the constitutional, what we call the constitutional dimension. Now, constitutional dimension here, what we really wanted to focus is about the status of the Hong Kong Basic Law within Hong Kong. Within Hong Kong. This is the Hong Kong legal system. Now, when you do your Hong Kong legal system, you will place your focus on a few things there. And the first thing is the preservation of the pre-97 system, which is the common law system, which is in practice. Yeah. And then as opposed to pre-97, where when Hong Kong was a colony, apart from the ordinances that are made or enacted by the Hong Kong Legislative Council, what is part of the Hong Kong legal system, and in fact it enjoyed the supremacy, are the constitutional documents made by UK, and those are the letters patent and the royal instructions. Now, just the third bullet point here, in Hong Kong Basic Law is the highest law with practical effect. Pre-97, it is the letters patent and the royal instructions, those constitutional documents which enjoy the status of being the highest law. And back to post-97, with the Hong Kong Basic Law, courts have been calling it a constitution. And I mentioned this last time that it is for convenience. That is a shorthand way of expressing or describing the status of the Hong Kong Basic Law. Hong Kong Basic Law, in legal terms, of course, is not constitution, but it's that status is that it enjoys. And with that status, that the immediate practical effect is any law which is found to be in contravention with the Basic Law, they can be declared to be so by the courts. The court can declare a certain law to be in contravention with the Basic Law. So what other effects that you will have? Well, just like other constitutions, for example, you look at the system, look at the content of it, and you will see that it has all the characteristics of a constitution. For example, Chapter 3, it defines the fundamental rights and duties of residents. Chapter 4, it set out the political structure of Hong Kong. Right? And then there are others. And for example, in Article 159, which provides for the amendment mechanism of the Basic Law, it is what we call an entrenched mechanism. What does it mean? Because under Article 159, if there was a need to amend the Basic Law, it's not like the making of it, which requires a simple majority of the NPC. For any future amendments, if any, first of all, there has to be a proposal made, and the proposal to amend can only come from designated bodies. One is the standing committee of the National People's Congress. The second is the State Council. The third is from the Hong Kong Special Administrative Region. Now, only these three bodies can make any proposals to the NPC for amending the Basic Law. If the amendment should come from the Hong Kong Special Administrative Region, then there are further conditions to be satisfied. First of all, it has to be submitted by the delegation of deputies to the National People's Congress. Right? In the National People's Congress, there are 36 deputies representing Hong Kong. And before they can introduce this as a group, the deputies have to obtain a consent from 2/3. The 2/3 of them have to agree before they can present. 2/3 of these 36, i.e. 24 at least, have to consent. And also 2/3 of the Legislative Council members, and then the Chief Executive. So only the delegation from Hong Kong SAR to the National People's Congress can submit this proposal to amend. But before they do that, they have to have 2/3 of the deputies agreeing. They have to have 2/3 of the legislators agreeing, and the Chief Executive. So very difficult, very complex, and this is what we call entrenchment. More difficult to change than other laws. And the other laws usually will be invalid if they found to be inconsistent with the Basic Law. And the question put here is, does the Hong Kong Basic Law meet these requirements, or do they have these characteristics? I think the simple answer is yes. The simple answer is yes. But then on the third point, though, the Hong Kong Court of Final Appeal had drawn support from Article 11. If you go to Article 11, I don't know whether you have your Basic Law with you right now, but if you turn to Article 11, by the way, I really would make it a point that you have to have your Basic Law with you when attending classes. If not physically, you should have access to it on your computer ready. Right? Thank you. So when you look at Article 11, the second paragraph says, no law enacted by the Legislature of Hong Kong SAR shall contravene this law. So courts in Hong Kong have drawn this as the authority, at the basis for making judicial declaration that a certain law passed by Hong Kong Legislature may or may not contravene the Basic Law. There is also another mechanism which it's becoming, it's drawing people's attention because of this anti-mass law, the anti-mass law. If you look at Article 160, and I saw that Simon, you've got your basic law here. Can I ask you to help me? Simon, I just turn on your microphone. Can you just help me? Can you help me to read out this provision? First paragraph. Upon the establishment of the Hong Kong SAR. Simon, can you hear me? Yeah, thank you.
Yes. Which paragraph?
First paragraph, Article 160.
Okay.
So our classmates will not be bored by the same voice, for the 3 hours.
On the establishment of the Hong Kong Special.
Yes, that's right. Could you take us through it?
The laws previously.
Could you sort of raise your voice a little bit?
Okay. Shall be adopted as laws of region except for those which the National People's Congress Standing Committees declares to be in contravention of this law. If any laws are later discovered to be in contravention of this law, they shall be amended or ceases to have force in accordance with the procedure as prescribed by this law.
That's right. That's right.
Yes.
And this paragraph comprises 2 sentences. The first sentence deals with the. Thank you very much, Mr. Ng. The first paragraph first sentence deals with what I call pre-97 ordinances, and it all started from 1992 up to 97. The mainland authorities actually had gone over each and every ordinance and draw a conclusion that on which of those ordinances can or cannot be adopted as part of the laws of Hong Kong SAR. And a decision was promulgated in February 1997. February 1997, and that was before the establishment of the Hong Kong SAR, which took place on the 1st of July 1997. And there were obvious ordinances which could not survive the resumption of sovereignty. Yes, Simon, you wanted to say something? I saw that you raised your hand. Oh, disable Simon. Somebody raised hand. I just saw. Who was it? Oh, Leung? No. Anyway, I was on this point about there were ordinances which obviously cannot survive the handover or resumption of sovereignty. For example, the electoral laws, the laws on elections cannot survive 97. And there were those laws, one piece of legislation which was particularly found to be objectionable and considered to be in contravention with the basic law was Section 3 of the Hong Kong Bill of Rights Ordinance. Hong Kong Bill of Rights Ordinance, and that was an ordinance that was enacted in 1991. And that ordinance was enacted after the June 4th event in 1989. It has the legal effect of making it law in Hong Kong, the International Covenant on Civil and Political Rights. And that International Covenant was made into Hong Kong law nearly word for word. nearly word for word. And because despite the fact that UK had signed that international covenant and agreed to extend it to Hong Kong in 1976 with certain reservations, that covenant did not become part of Hong Kong law until it was enacted into an ordinance, right? So that is the because of the nature of the legal system that we have, is a dualist system. So not until it's enacted. And in that ordinance, Section 3 gave a precedence to this particular Bill of Rights ordinance, and it provides that the courts shall interpret all the Hong Kong ordinances consistent with the International Covenant on Civil and Political Rights, or rather consistent with the Hong Kong Bill of Rights. And for those that the court could not so interpret, then they will be presumed to have been repealed and cannot continue to have the effect of the law. Now, on this particular one, the Chinese government took the view that that would be in contravention. That was in contravention with the Basic Law, and therefore, in the decision of February 1997. I didn't. Okay. Thank you, Michael. But they are really late, aren't they? Anyway, I didn't see them. I didn't see the request. Right. Oh, they got kicked out. Oh. Well, I hope they will try again. Okay, I accept that. And this is unfortunately, we have to bear with this risks of technical difficulties. Yes, I understand that. Yeah, I'm not trying to put blame on anyone, but only that. Yes, now I saw them and I've accepted them. I see. That's very unsatisfactory, of course, but we have to live with it. I think that's the best we can do. In fact, Hong Kong Youth Space has provided this this program, which I think is doing a lot of service to us. Without that, we couldn't even have these classes. Anyway, I back to what I was saying. So there were some legislation which were declared not to be adopted as part of the Hong Kong law, and that is under Article 160. So you can see that the Hong Kong Basic Law does provide a mechanism which determines the validity of laws maintained under Article 8 of the Basic Law, and so that is really, you can sort of therefore gauge the status of the Basic Law as something, as a piece of law which, although not being called Constitution, does have that status. Yeah. Now the second sentence that was read by Simon is this. It says, if any laws are later discovered to be in contravention of this law, they shall be amended or cease to have force in accordance with the procedures prescribed by this law. So February 1997, following that decision, the Basic Law actually being, I suppose it was first of all being prudent, i.e. it didn't say, well, it didn't rule out any possibility that they might have overlooked certain ordinance and had allowed it to continue to have force. Secondly, and which is a pragmatic view, is situations might change, and since then, and therefore, for whatever reason, that may have rendered a particular ordinance in contravention with the Basic Law. And one live example that we had right now, it is before the Court of Final Appeal, is in relation to the Emergency Regulations Ordinance. Emergency Regulations Ordinance. Under that ordinance, the Hong Kong SAR government made the prohibition against facial covering regulation, i.e., that regulation forbid or prohibit the wearing of facial mask in a public place, be it at the time when there is unlawful assembly or riot, or even during a time when there is authorized public assembly. And the wearing of this mask is an offense unless there is a reasonable excuse or lawful authority for doing so. And there was this case before the court. I don't know whether you have read about that. Have you read about that case? The case about the anti-mask? There were 24 legislative councillors who took court action, judicial review in court, and challenging the lawfulness of those anti-mask regulations. One of the grounds of the challenge was that the Ordinance, Chapter 241, the Emergency Regulations Ordinance, was in contravention with the Basic Law. Although it had been adopted by the Standing Committee of the National People's Congress in February 1997 as part of the Hong Kong SAR law, the challenge was that law had given too much power, too general legislative power to the chief executive, and which was in contravention with the political structure established by the Basic Law. So Simon, you said you're aware of that. That's good. And anybody else? I saw that you're typing, but I'm waiting. Did you know the result of the case? Could I ask, while Simon is typing, could I ask one of you to tell us about the result of the case? Ngao Xiu Tong, are you there? Can you tell us? Ngao Xiu Tong? Or Michael check? Michael check? Yes. Can you? I turn on your mic, Michael. Can you tell us what did you know about this case? The case result? Yes, Michael. I just turn on your. No.
Yeah, can you hear me?
Yes, I can.
Yeah, sorry. What was the case again?
Is this the information ordinance? arising from the of the anti-infringement master.
It's so laggy here.
What do you mean?
It's so laggy here. I don't know. I can't hear you very well. What was the question again? What was the question about the case or something?
The result of the case. It was a challenge against the ordinance based on which the anti-mass law.
The connection is very laggy here.
Yeah, I can.
Probably you might want to pick someone else instead of wasting
Yeah.
time. Sorry about that, sir.
Okay, don't worry. I'll try what next online. Chen Pak Ho. Chen Pak Ho. Are you there? Chen Pak Ho? No? Are you there at all? Chen Pak Ho? Are you there at all? Yes. Do you have your mic on? Okay. In that case, it's a pity. Who has a mic on and would like to contribute to this? iMac desktop. Okay. I don't know, the significance of whether you are using a mic, iMac or what. I saw that Leung Kam-xun, you've got your mic there. Is your microphone on? Yes. The question is about the Emergency Regulations Ordinance. It was being challenged as being in contravention with the Basic Law, and that was in relation to the making of the anti-mass law, that is the prohibition of facial covering regulation. My question was whether you knew the result of that case. Are we connected there so that you can try answering the? First of all, do you know about the case? Leung Kam-xun, or can you just tell us? There's no need to type if your mic is on. Could you let us hear you?
Hello?
Yes. And you are? Yes, you are?
Yes. Can you hear me?
Yes, I can. Are you Leung or are you someone else?
I'm Leung Kam-xun, yes.
Yes, it's Leung. Thank you. And did you hear the case that I described? Did you know about that case?
I didn't study the details about this case, so would you give us some more information about in what aspect the case may may contravene with a particular article? Yeah.
Now, it was alleged. The complaint was it had given the chief executive the power to make law too generally without restrictions, as if the chief executive was discharging the function of the lawmaking body.
Mm.
And under the Basic Law, Article 66, the only lawmaking body is the Legislative Council.
Mm.
So for that reason, one of the complaints was that that law was in contravention with the Basic Law, despite the fact that it was adopted as part of the laws of the Hong Kong Administrative Region in February 1997 by the Standing Committee of the National People's Congress in accordance with Article 160 of the Basic Law. Right. So that was briefly what was that issue that relate to Article 160. Park Shing, you have typed out the Court of Appeals ruled that the ERO, which is the Emergency Regulation Ordinance, was in fact constitutional on occasions of public danger, and therefore the prohibition against facial covering regulation was not invalid on those grounds. Yeah. So Ms. Leung, that summary was correct, and you probably haven't read it or simply didn't know about it. But our focus is really for me to bring out the legal effect of the second sentence in Article 160. Second sentence being that there may be occasions after 1997 that certain ordinance may be found to be in contravention with the Basic Law. And indeed, with this particular case, the Court of First Instance, comprising two High Court judges, did find that the ordinance contravened the Basic Law. But when it went to the Court of Appeal, the three judges of Court of Appeal decided otherwise, decided the opposite. Okay, so, and indeed the case itself right now is before the result of this case was partially held. Now, anyway, this case right now is before the Court of Final Appeal. The Court of Final Appeal hopefully will soon render its decision soon. And Simon, I'm not quite sure, what did you mean by partially held? Could you tell us? Simon, I just turned on your mic. Could you tell us?
Okay.
Simon?
Can you hear?
Yeah, I can hear you quite clearly. Yeah.
As I heard from you.
Oh, can you come again?
Hello?
Yes. I can hear you.
Okay.
I was asking you to expand on what you said, what you wrote about partially held.
As I know that the case in appeal, the Court of Appeal is how that the law can be made by the government in some conditions, and just like the legal assembly. So I think this is the result was partially held.
I'm sorry. Again, it didn't. It's the voice that didn't come through too clearly. Could you say that again?
Hello?
Yes, Simon. Yeah. Can you say that again? Just repeat, please.
As I know, the court held that the anti-mask law can be applied in some situations and cannot be applied in some situations. So that's why I said that the result of this case is partially held.
Okay. You are right, but of course our discussion had been on the constitutionality of the Emergency Regulations Ordinance. You are right about the partially held because the Court of Appeal, if you refer to Court of Appeal, the Court of Appeal held that part of the prohibition against facial covering regulation, some of which cannot survive the human rights test, some of which were unnecessary and disproportionate. But that is on human rights, and we're going to look at those later on human rights. But as far as the constitutionality of the ERO, Emergency Regulations Ordinance, is concerned, the Court of Appeal overturned the Court of First Instance and held that it was constitutional. Did you get this one, Simon? Did you get it? Did you get what I say? Okay, thank you. And the case is now before the Court of Final Appeal. It was heard on the November 24th and 25th. So hopefully, Court of Final Appeal will render its judgment, will hand down its judgment. I think, hopefully for another 2 weeks or so. Hopefully before Christmas, we will know the result. Park Shin, you gave us a link. Is there a link to the? Let me see. Is it the link to the CA judgment? Yes. Right. It's a. This is the CA judgment, right? So you should, when if you are interested, do take a deeper look at the judgment. It covers more aspect, not only the constitutionality of the ordinance. It also covers other human rights aspects. So you should read this. Okay. Thank you. So going back to Article 160, this is a case, at least at the first instance, at the Court of First Instance, it was held to be the ordinance was held to be in contravention with the Basic Law, and this is the word discovered. It's meant to cover. When Article 160, it says later discovered to be. It doesn't say later decided by the court to be. It's a term which may still need to may be subject to further interpretation. But in the case of in the Court of Final Appeal case of Hong Zhenhua, it was held by the Court of Final Appeal that a court making a declaration of constitutionality must be one of the circumstances. And if it so happen, then the particular law should be amended or cease to have force in accordance with the procedures prescribed by this law. And one of the procedures, of course, is for Legislative Council to undertake a legislative exercise to either repeal that law formally or to amend that law so that the offending parts could be repealed, and what then may result is the law will not continue to be in contravention with the Basic Law. And the next slide I want to take you to is just one quotation from this case, Ng Ka Ling, which summarizes pretty accurately and what we call the constitutional dimension of the Basic Law. The court says that the Basic Law is a national law because it was passed by PRC and therefore it applies to the entire country, and is the constitution of the region. And I just explained to you that it's a shorthand form of saying it is the law in in the region which enjoys the highest status within Hong Kong. Like other constitutions, it distributes and delimits powers, as well as providing for fundamental rights and freedoms. And as with other constitutions, laws which are inconsistent with the Basic Law are of no effect and are invalid. So that summarizes the characteristics of the Hong Kong Basic Law. However, this was a statement made in 1999, and it has since been subject to certain criticisms. As I had said, some scholars, some even politicians, thought it's not correct and not politically correct, at least politically correct, to say that to describe the Basic Law as a constitution of the region, and some even had gone to the extent of saying that it is not for the courts to declare that a law is of no effect or invalid. That has to be done under Article 160 through the prescribed procedures, and that should be something for the Legislative Council, or even some argue that it should be under Article 17 of the Basic Law, under which the Standing Committee of the National People's Congress can return a law to the region. Can return a law to the region, and then from the moment it's returned, it will cease to have effect. It's only then. Now, these are issues which have not been further decided by the courts in Hong Kong, nor had it been under any Standing Committee of National People's Congress interpretation. So there is room for arguments. Right. The next slides that I wanted to take you through are those on the relationship between the Basic Law and the PRC Constitution. That being the case, I think we'll take a break from at this moment, and we will return in 15 minutes. I'll see you after that. Thank you. I was going to take you to looking at the relationship between the Hong Kong Basic Law and the PRC Constitution. We put in a note there to say this is a different topic from the three dimensions of Hong Kong Basic Law. This is the legal relationship between the two, rather than the Basic Law as it applies in Hong Kong, where it has the three dimensions: the international, domestic, and the constitutional dimensions. Now, without looking at further slides, one obvious thing to you, of course, from the appearance of these two documents, they are of different degree of red, different shades of red. The Constitution looks bigger a book than the basic law. And what else are different? Or what else are the same on the face of this? What are the similarities? What are the same? Anything that you find are actually the same? Can I ask you? Hmm? 吴嘉怡 Can you hear me better now? Sherry? Or Coco? Are we there? Do we have sound? Anybody responding? That's very... Can you hear me? Good. Thank you. Thank you. Yes, that's very good. That's very encouraging. So, Jia Yi told us about the national emblem. Yes. What else? Or is there anything else? The language? Yes. In what sense? Can you talk? Jia Yi, can you talk? Are you talking? Are you speaking? I can't hear you. I turn on your mic. Michael, you have been going in and out of the room, aren't you? Cantonese in Hong Kong while Putonghua in mainland. Haha. This is a very interesting question. Well, just digressing a little bit. Just a little bit of digression, yeah. Talk about language. If you turn to the Basic Law, Article 9, Article 9. Do you have your Basic Law with you? Article 9. Let me open my Basic Law. Oh, somebody just have it. I was going to do that too. Right. So that's Article 9. There's no Cantonese reference to Cantonese, is there? Yeah? Mbashing? Or who was asking that? Oh, Xun. It's an interesting one, isn't it? So the basic law, the Hong Kong basic law doesn't deal with the dialect, but it makes reference to the Chinese language, whatever that means. And even in the Hong Kong's ordinance, Hong Kong's legislation about the official languages, ordinance, and neither is it making any reference to Cantonese, and that is in the section 3 of the official languages ordinance. Article 19 of PRC Constitution, the state shall promote the common speech, 普通话, used nationwide. Nationwide use of 普通话, common speech based on Beijing pronunciation. Yeah, you're quite right. So, but it doesn't deal with the status, right? The official status. In any event, in practice, we see that Hong Kong's policy encourages or the use, not encourages, but the use of Cantonese dialect is the most common phenomenon. But when it comes to written language, of course, is Chinese, and then the issue is simplified Chinese or traditional Chinese. Hong Kong still, in general, and also within government, uses the traditional Chinese characters as opposed to the simplified Chinese characters. Jia, I have no clue as to why for this particular version of the Constitution, the book cover has the English placed above the Chinese, but I suspect these are not official publications anyway, so please don't draw any. All my questions asked about these two documents really to generate your interest in focusing on their contents rather than their appearances. But you can see that there are, just from the look of it, the apparent differences. And thank you for raising the question about 普通话, Cantonese, Chinese language, and there is really, that's all that I can offer you. From a legal point of view, of course, the PRC Constitution of 1982 is the highest law in all of China. It's the fundamental law. It's the fundamental law. Is in Chinese is 根本大法是吗? And sometimes it's described as the mother law, is the 母法. So it's the source of any law. And in China, the legal system is such that belief under the National People's Congress there are other governmental institutions which are given lawmaking powers at the different hierarchy. And we have to be very careful when we look at the law in mainland China to identify the status of the law that you are looking at. The Constitution provides the legal authority for all the laws in all parts of China, including Hong Kong. So all parts of China, all these institutions from State Council to provincial National People's Congress, or the equivalent of this Congress at municipalities that are given, and autonomous regions that are given delegated lawmaking powers. They have their source of power at the National People's Congress. And the Constitution mainly is about the socialist system being practiced in mainland China with Chinese characteristics. This is the ideology base is the most important driving force, the most important rationale for this, for the existence of PRC. Coming back to Hong Kong SAR, when you go through the Constitution, you do not find any reference to one country, two systems. Now, in our concept of the rule of law, I think is accepted that anything to do with the system of government should have its source from the law. And the Constitution being the highest law in the land, shouldn't it have reference to this very important national policy? One country, two systems. Well, the answer is no. The answer is you do not find it. You do not find it directly mentioned in the Constitution. That being the case, an obvious and natural question is therefore the one country, two systems against the PRC Constitution? Is it against or is it not against? Or is there no answer? Of course, it's an important question, and yet on the face of it, there's no clear answer. The why is it not clear, not easy to answer? It's very much due to the nature of the PRC Constitution, where under Article 1, it's made abundantly clear that China is a socialist state under the People's Democratic Dictatorship, led by the working class and based on the alliance of workers and peasants. That is Article 1 of the Constitution, and it goes on to say the socialist system is the basic system of the People's Republic of China. Disruption of the socialist system by any organization or individual is prohibited. So that is the bedrock, the founding stone of the entire Constitution. Article 1 under Chapter 1, General Principles. Is there any socialist system under one country, two systems? This is a question asked in this context. Is there the socialist system, or is there not? It's a simple question, though, not difficult at all. It's basically asking you, what actually is the one country and what actually are the two systems under one country, two systems. So what is the one country? Yes. And the two systems? Yes, socialist system with Chinese characteristics is the one of the systems, and the other the capitalist system. That seems pretty straightforward, seems quite logical too. But of course, what is difficult, though, I think, is there's no legal definition of what these two systems are. And we may have to, therefore, defer to other sources for identifying or for describing correctly what these two respective systems are. Some may even say that today the divide between the two, if there had ever been any divide, has become so blurred that you can't really tell whether the system now in practice on mainland China is or is not a capitalistic system. So as the one that is now in UK, it seems to be even more socialistic than any other socialist country. Which is difficult to judge. However, what is important, of course, is the fact that there are two systems. Now, the fact that there are two systems doesn't necessarily mean that they do not have anything in common. Sometimes you may think that it's just a matter of semantics. Systems, they are just common sense. One may argue that no two systems are the same in this world. And therefore, when you say two systems, itself doesn't have any practical significance. As long as there are two systems, they may bear more resemblance or less differences, either as a matter of fundamental definition, fundamental feature, or in practice when the two systems interact. If they do interact, and in fact we see a lot of interaction of that, they will probably evolve from having more differences at the beginning to less and less differences. Whether it will come to a stage where the two systems will be merged into one is a different question, because the two may continue forever to be two systems only qualified by or only involve more and more resemblances. Yeah, that's correct. This socialism with Chinese characteristics is a way of describing it. Now here we are into an area where very different from when we studying different from studying other areas of the law. In this case, some of the concepts are not susceptible to exact, precise definitions. Right? A so-called a socialist state, which appears in the Chinese Constitution, it must have its meaning, and that, of course, is in the context of socialist system, and so that is the concept that I wanted you to understand. One country, two systems. One country, no doubt we are referring to PRC, and the two systems are the respective socialist system as described in the Constitution, and the capitalist system as described in the Hong Kong Basic Law in Article 5. In Article 5. And it is, in a way, is fortunate that because Hong Kong had a history, and as far as the question of what sort of capitalist system we are talking about, Article 5 of the Basic Law made it very clear. It is the previous capitalist system, the previous capitalist system. So the emphasis is not only on the nature of it, but also on the how that is identified. And that is the same system as was in place before July 1st, 1997. And what is being maintained, of course, is not only the system itself, but also under Article 5, it is the way of life. It's a way of life that is being maintained for 50 years under Article 5 of the Basic Law. Still on the relationship between the PRC Constitution and the Hong Kong Basic Law. Article 55 of the PRC Constitution 1982 provides it is the sacred duty of every citizen of the PRC to defend the motherland and resist aggression. It is the honorable duty of citizens of the PRC to perform military service and join the militia in accordance with law. China doesn't have a prescription, doesn't have a mandatory military service requirement. It's treated as an honor to become a member of the military service. The question asked is, do Hong Kong people have a duty to perform military service? Do Hong Kong people have a duty? No. But what's the logic? Are Hong Kong people citizens of PRC? Are Hong Kong people citizens of PRC? Yes, no, yes, no. Well, not yet. It's a difficult. Well, if you look at this as a matter of logic, then it seems because Hong Kong SAR is part of PRC, is an inalienable part of PRC, then maybe by logic, if you are a citizen of Hong Kong, you are automatically a citizen of PRC. Look at the news I watched last night. Shenzhen is actually recruiting civil servants from Hong Kongers, from Hong Kong people. Now, in previously, the question here asked of you is about military service. Do Hong Kong people have a duty to perform military service? Well, to be quite honest, even people of the mainland, they do not see it as a duty, do they? The Constitution says it's the honorable duty to perform and to join. So it doesn't mean that it's a legal duty you have to. But when the people do join, they see it as an honor. They see that as an honor. It's not an easy question to answer. And as far as whether Hong Kong people have a duty to perform, some of you say no, some of you say yes. In any event, there's no compulsion. That's for sure. You're not compelled to. Right? And in practice, whether you are qualified to, even some people may think that, oh yes, I am very interested. I just wanted to serve the country, and I want to become a member of the military service. Can I? And that has been difficult to find an answer. Next, again, another one. There's no socialist system in Hong Kong, and Hong Kong people cannot join Chinese army. This cannot join is because of a lot of other criterion, and it's a political fact. The next legal question that students are often asked, yes, Michael, you brought up another point. We are residents of Hong Kong SAR. When you look at the basic law, it refers to residents rather than citizens or nationals. That's not the way it's described. So in the Article 24 of the basic law, Article 24, we're talking about residents who are permanent residents. Okay, so that's another point. And interestingly, the official translation of the word citizen is used instead of nationals. On this slide, so just to confirm that there's no socialist system in Hong Kong, and Hong Kong people just cannot join Chinese army at the moment. And the next question, sometimes we pose it as an exam question for you, but obviously not asked in that straightforward manner, but may involve an analysis of the legal position. So if on the question, is one country, two systems against the PRC Constitution? The simple answer is that Article 31 seems to make an exception for SARs, i.e. Hong Kong and Macau, and it says that the MPC, because it says that the MPC can make basic laws on systems in the SAR. But it doesn't directly say different systems or two systems, right? It just says that it can make systems. So what does it say? Let's go to the words of the article. The state may establish special administrative regions when necessary. The systems to be instituted in special administrative regions shall be prescribed by law enacted by the National People's Congress in the light of specific conditions. So it doesn't say anything more than what it says, obviously, and it doesn't say that system instituted has to be different from that on the mainland. And our question is, why is Article 31 of the Constitution so important? Well, why is it so important? No Article 31, no Hong Kong SAR. It is the ultimate source of all legal sources of Hong Kong. Well, the legal analysis is this. Let me see. Yes, the legal analysis is fairly straightforward. Just remember, do we all remember, in the joint declaration, wasn't it an undertaking by the PRC government that the basic policies will be contained in the law? It's an international commitment there, isn't it? And of course, by that time, the Constitution had already got Article 31, and that gave China the basis to make that promise, because as we in a body, for a body which abide by the rule of law, there must be a law which provides the authority for it to do what it is undertaking to do. And on this occasion, it is the making of a law which allows the previous system and the way of life to continue after 1997, and that of course make it that important. So without Article 31, for one, PRC may not be able to give the undertaking, and for two, even if it gave the same undertaking in the same terms, if there was an Article 31, the other parties may have difficulty in relying or in giving PRC the necessary trust that it will honor the promise. So that's why Article 31 is so important. So without Article 31, just like Jia Yi said, there will be no Hong Kong SAR, no Hong Kong Basic Law. All right. Are we okay? There is a little bit of repetition here, but only to put it beyond doubt, to make it absolutely clear that there is this Article 31 is so important, and the preamble cannot go without making reference to it, direct reference to it. It says a Hong Kong SAR will be established in accordance with the provisions of Article 31 of the Constitution of the PRC, and that under the principle of one country, two systems, the socialist system and the policies will not be practiced in Hong Kong. That is the preamble to the Hong Kong Basic Law. And then Article 11, there are two parts. We had looked at the second part of Article 11 earlier, which provides that no law can contravene the basic law. Article 11, the first paragraph, articulates and provides the relationship between PRC Constitution Article 31 and that of whatever all the systems being established by the basic law. It says, in accordance with Article 31 of the Constitution of the PRC, the systems and policies practiced in the Hong Kong SAR, including the social and economic systems, the system for safeguarding the fundamental rights and freedoms of its residents, the executive, legislative, and judicial systems, and the relevant policies shall be based on the provisions of this law. It tells you the source of authority for laws in Hong Kong in the areas as set out: social and economic system, system for safeguarding fundamental rights and freedoms, and of its residents, the executive, legislative, and judicial systems, and so on. So all these have to be rule-based or basic law-based. So Article 11. So to answer taking you back to the very big question asked. The very big question asked, is one country, two systems constitutional? Constitutional means comply with the Constitution. Unconstitutional means it contravenes the Constitution. the starting point is Article 31 does not directly mention one country, two systems. So some Hong Kong Basic Law drafters worry that the Basic Law may be unconstitutional. The National People's Congress responded to this concern by making a decision in 1990, the same time when the Basic Law was passed into law by the National People's Congress. It decided that the Hong Kong Basic Law is constitutional as it is enacted in accordance with the Constitution. So the conclusion is, on a matter like this, which is a reflection of a country's commitment, what is intended to achieve is more than what has been done in terms of words expressed or words enacted. Although there was no mention in Article 31 to one country, two systems, and which is quite clear, although it's not directly mentioned, because otherwise, why else should that be mentioned, that there could be other system? It must be a one country, two systems concept or policy that the that the central authorities had in mind at the time. And because of this concern about the constitutionality of the establishment of a special administrative region, not practicing socialist system but capitalist system, the National People's Congress actually made a decision on the Basic Law's constitutionality, to say that it complies with the Constitution, on the very same day when the Basic Law was passed into law. That was 4th of April, 1990, that the Basic Law was passed, and followed by a decision confirming that it does not contravene the Basic Law. Right. Any questions before I move on to a new topic? Any questions? No questions? Okay. High degree of autonomy under one country, two systems. That is the heading of our chapter 4 of the menu and also of the textbook. Well, Article 31 is the foundation. Yeah. Well, let's go on to looking at, in fact, the next few slides will give you at least, not perhaps the rationale, but the practical arrangements within PRC and how this high degree of autonomy under one constitutional systems may be different from how the how the what the basic policy is in the PRC on the establishment of autonomous regions. Useful reading, the white paper 2014. This is a white paper, as the name suggests, published by State Council. State Council in Chinese is 国务院, 国务院, 国务院. It is effectively the government, and so it is not a judicial body. And back in 2014, it published a white paper, which in the system in Chinese system that goes to, this is official publication and is published for the sake of explaining certain government policies, obviously from the government's perspective. 2014, this publication of this white paper also drew a lot of controversy. One of which was, if you remember, was describing judges as a member of the governing team and bringing them to become members of the team comprising both the executive, the judiciary, and the legislature, and that to many, including the Bar Association, had expressed concern that it actually goes against the basic law, and in various aspects, including the aspect of separation of power or independence of the judiciary. You can find this is not a long paper. You can find this from the internet quite easily. The next is Mr. Gidding's book, Chapter 4, High Degree of Autonomy. It's very well written, so you are encouraged to take a quick look at Chapter 4. First of all, let's again go back to the Joint Declaration, and it is within the Joint Declaration that it was promised, it was said that Hong Kong will enjoy a high degree of autonomy, except for foreign and defense affairs. This is reflected in Article 2 of the Basic Law. It says that the National People's Congress authorizes the Hong Kong Special Administrative Region to exercise a high degree of autonomy and executive, legislative, and independent judicial power, including that of final adjudication, in accordance with the provisions of this law. So Article 2 brings out the important concept of authorization. Whatever Hong Kong SAR is given, it is given by way of authorization. The characteristics of authorization is this. First, the principal can only give you as much as it enjoys. Now, NPC, of course, is the highest organ of power. So it is from there that the special administrative region is delegated and given high degree of autonomy, meaning enjoying executive, legislative, and independent judicial power. And in terms of judicial power, it goes on to say, including that of final adjudication in accordance with the provisions of this law. So Article 2 of the Basic Law encapsulates that and crystallizes the whole concept of high degree of autonomy, and it's exactly there in the article. However, because it is degree, we are not talking about autonomy in absolute terms. We are talking about a high degree, and it doesn't say that this high degree will remain constant, will not change, or does it change according to whatever. I don't think that the one can find an answer there, except it is more it's so typical of a compromise, and that the parties involved did not want to be that particulars, but wish to leave it for future interpretation. And of course, on this one, normally a law, the proper interpretation of a law will have to go to the court in Hong Kong. However, in the case of the Basic Law, and because of the standing committees of NPC's power to interpret the law, it may be more realistic that we will study the provisions in their proper context and then make our judgments, rather than taking the matter to court every time. Okay. But what is characteristic is the fact that this autonomy can be translated into the way it is provided here. The autonomy, the SAR enjoys executive, legislative, and independent judicial power. So what does autonomy mean in this context, where the part of the country has separate powers of internal administration? Now this is words from the political scientist, and on page 38 of the course menu, you'll find that Crawford, as a legal scholar, not as a judge, has defined autonomous as follows. It says autonomous areas are regions of a state, usually possessing some ethnic or cultural distinctiveness, which have been granted separate powers of internal administration to whatever degree, without being detached from the state of which they are part. So it talks about the power to spend autonomous areas that usually possess. this is talking about attachment and detachment. So there has to be some association, and this can be called, and these are called autonomous regions. So they have ethnic and cultural distinctiveness. They enjoy separation of power by having internal administration. So by Crawford's definition, it indicates that autonomy is usually granted to regions that are ethnically and culturally different from the rest of the country of which they are a part. So these culturally different groups are, for example, people from Tibet and Xinjiang, Quebec in Canada, and Scotland, and Wales, and Northern Ireland in the UK. Tibet, Xinjiang, and other areas of China with significant populations who are not ethnically Han Chinese are called national autonomous areas. And what do they have? What do they have? They enjoy a limited degree of autonomy under the PRC Constitution, and this is sometimes called the ordinary autonomy. And under the Basic Law, both Hong Kong and Macau, they enjoy a much higher degree of autonomy. So that is how the status of, or the concept of autonomous, of being autonomous is described by various scholars, including Crawford. There are parts in China which has been an autonomous region for many years, and these are like Xinjiang, as I just mentioned. But these, in Chinese concept, these places enjoy, what they are having now is ordinary autonomy. Whereas for Hong Kong and Macau, they are special autonomy and enjoying a high degree of autonomy. For Hong Kong, of course, it doesn't have an ethnic or distinctiveness among the residents, nor do they have one unique culture. So in terms of therefore turning Hong Kong into an autonomous region, is in a way is problematic. Generally, it is believed that it will be in everybody's interest to leave matters as they are in the terms of the Basic Law. We have looked at examples around the world, and also in China. In China, the Constitution, 112 and 122, provides for the establishment of national autonomous areas. This is organ of self-government and national autonomous areas. 112 says that the organ of self-government of national autonomous areas are the People's Congress and People's Government of Autonomous Region, Autonomous Prefectures, and Autonomous Counties. So the system is the same, but at a much lower and simplified scale, lower level and much more simplified scale. And we can see not only in China, Tibet will be one of the examples, but there are others like Greenland, which is part of Denmark, and in the case of Scotland, it is part of UK, and in many areas of governmental activities, Scotland doesn't have to be answerable to London. So that's Scotland, Greenland, and Tibet. There are these different degrees of autonomy. You should note there is the ordinary autonomy in national autonomous areas such as Tibet, and then the high degree of autonomy such as Hong Kong. But this is not a complete autonomy. So, in a sense, no matter you call it high degree, ultra degree, whatever, it is still not simply autonomous. When you are just autonomous, i.e. complete autonomy, then the motherland will have no role to play or to say. But before then, it still has some power over Hong Kong. Some may be legal power or moral power. And if for the autonomous regions, we next ask what is high degree. We try to borrow concepts used by some scholars, and here we're making reference to what Professor Hannum said, and these are the characteristics. What they say is of places with given autonomy. First is the locally chosen chief executive, responsible for local laws, and then they have a locally elected legislature making laws on local matters, independent local judiciary with jurisdiction over local matters, and an independent mechanism for resolving any disputes, independent court system, for example. You are asked to go to learning activity for chapter 4, which is on my page 43. On my page 43. For those who have already got your menu, can you turn to that? Learning activity 1. So Professor Hannum has identified some common characteristics, and they are now listed out here in the table before you. And you are asked now what to do is to indicate which one apply in Hong Kong and which one does not. And for these characteristics you believe do apply, you should also find and include the relevant articles numbers in Hong Kong basic law, and you should be prepared to explain your answers. So, locally chosen chief executive with responsibility for administering local laws. Is that applicable in Hong Kong? If yes, then what are the relevant articles? Can anybody deal with the first one? Locally chosen CE with responsibility for administering local law. No? And then you say Article 45. You mean not applicable in Hong Kong, locally chosen. Can you explain your answer? So are you saying that although there is election, which is a form of choosing, and yet because the appointment has to be finally done by CPG, therefore it doesn't fall within the description, come within the description of locally chosen, because you do not choose your CE, but you choose a person to be appointed by CPG as the CE. Is that what you wanted to say? Thank you. And relevant article is 45. That's fine. Second, locally elected legislature with power to make laws on local matters. Applicable in Hong Kong? Is there somebody else who can help us? Is Chen Jiyan? Chen Jiyan, are you here? Chen Jiyan, are you here? Chen Jiyan, Chen Yuman, Chen Yuman, are you there? Chen Yuman, are you there? Chen Yuman, are you there? Are you there, Chen Yuman? Zhang Honman. Yes, thank you. Thank you for the hi. Did you hear my question? This is on learning activity 1, page 43. Page 43. Jane Honman, did you hear my question? Thank you. So could you deal with that question, Jane Honman? Does Hong Kong have a locally elected legislature with power to make laws on local matters? Yes, Annex 2. Yes, Article 68. Jane Honman, you said 2. What does he mean by 2? Jane Honman. Article 67. Hey, that's interesting. What about Article 67? What does Article 67 say? Hmm? Can you answer? I mean, John. I mean, Philip. Can you expand your answer? Philip, did you have a chance to look at Article 67? Can you actually talk? Because it's taking a long time. It could be more focused to deal with the local affairs. I'm not quite with you. I'm not with you at all. What do you mean by that? Could you? I can turn your mic on so that you can tell us what without having to type. That may be easier, wouldn't it? Can I enable your mic?
Yes.
Philip,
Hello?
can you
Hello?
hear me? Yeah. Can you expand on
Yes.
the road? Because I think it will be easier for you to
Yes.
say what's
Yes.
on your mind. What was it that
Yes, I
when you make reference to Article 67?
Hello? Hello?
How is it that?
Maybe
Yes, I can hear you.
this article
Yes. Yes, Philip.
maybe this article a
Hello. I can
majority
hear you.
of members to be local citizen to be more focused on local affairs.
What's the other side of the coin? The other side of the coin is why can't they have 100% then?
Maybe so I have no idea about that. Sorry about that.
Now, we are in the context of looking at high degree of autonomy. Yes, and for that, we are taken to look at the characteristics of an autonomous area. And it is said by the scholar that one of the characteristics is to have a locally elected legislature with the power to make laws on local matters. I think the question therefore is, does Hong Kong have a locally elected legislature, first of all? Does Hong Kong have such a
No.
the legislature?
No.
Philip.
It should be approved by the central government.
I'm afraid that is not the case, is it? Legislative council members do not have to be approved by the Central People's Government. Or are you saying that we Hong Kong people do not have a locally elected legislature because the Central People's Government can DQ candidates from being from running an election in the Legislative Council election? Are you saying that?
Maybe, if I understand. Maybe. Yeah.
Did you understand what I mean by DQ?
It's
Yeah. What do you understand by that? Yes. So, and do you know what is the disqualification mechanism at the moment? Why and how and why people can be disqualified? Do you know?
Yeah.
I mean, have you read news about that?
Maybe.
Yes. What is the
Maybe
latest piece of
it's,
news on the disqualification that you read?
Restricting the operation of the Legislative Council, or just affecting the normal operations of the Legislative Council.
You mean the disqualification of members has affected the operation of Legislative Council? Or what actually did you mean? Affecting the operation of Council? I'm not talking about the resignation, right? Now, isn't it the case that recently 4 Legislative Council members have been ordered to discontinue their office of being a Legislative Council member?
Yes.
You read?
Yes.
Had you read about that news?
Yeah.
Had you read that news? Yeah. There are 4 of them, right? And then, do you know the reason, the ground that they were disqualified? Do you see Mr. Ng had typed out in legal mind the DQ was based on Hong Kong Basic Law Article 104? Did you read that? Can you see that?
No.
Yeah. Park Shing just type in this in our chat box. You see that?
Okay. Maybe the reason is not. Yeah. Maybe it's not uphold. Yeah. Maybe the reason is on the Article 104. It's based on, yeah, it's not.
Maybe the reason is on Article 104.
Not upholding the basic law.
What was it based on?
Hong Kong basic law.
Well, Look Chi Ping says it's 無需有. Well, I mean, let's look at it from a legal point of view. I think it was based on the interpretation of the Hong Kong Article 104 of the Hong Kong Basic Law, and to be more precise, is they were considered not to be in holding allegiance to or upholding the Hong Kong Basic Law and holding allegiance to the Hong Kong SAR of the PRC. That was the legal reason. We put aside politics, but that was the legal reason. And in fact, that legal reason had been the basis on which the returning officer of the Legislative Council election had decided that they were not qualified to becoming a candidate in the Legislative Council election, right? So that was that. The reason why we were focusing on this was because of Philip's reference to Article 67, and then I then move on to bringing you focus on back to the characteristics, which is, if you look at your manual, page 43, the second characteristics is locally elected legislature. And we were focusing on whether Hong Kong has a locally elected legislature. And there we brought in the one perspective was this locally elected legislature may have room for interference by the central authorities, that it changed the nature. It may not qualify as a locally elected legislature because some people, some intended candidates may be disqualified, and therefore the election may not qualify as a true election. So that's how the logic goes, how the legal analysis can go. Okay, so we are still on this learning activity number 1, which I hope you will be able to continue yourself, and then coming back next time to working on it together. May I ask you for confirmation? Now, when is our next lesson? Is it on Thursday, right? Isn't it? Isn't it coming? And then, are we going to have a lesson on Saturday? On the 19th as well? Are we not? I wanted a confirmation from you. Because there have been some change, right? Good. And for the lesson on the 19th, we will start. We should start at 2:30 p.m. All right. So let's. And so for you, as a piece of homework, please prepare yourself to discuss learning activities 1 in chapter 4. Shall we? And do bring a mic that you can talk to, and then we can discuss this together. Shall we? I will appreciate that very much. Right. So let's call it a night, and thank you so much. It's obviously a long day for many of us, and hopefully you will have a good evening, and hopefully between now and Thursday you have a time to turn on to get to the text, got to the menu, and do a bit of work there. And if you're still not receiving your menu, please contact the office and chase them up. I think the menu is 43. You're quite right. Yes. Padel is page 43, please. Page 43. Right. Good night, everybody. Thank you for paying attention, and we will carry on Thursday.